So welcome everyone to our webinar on managing employee sickness and absence in the workplace. My name is Ruby Mills and I'm an associate in LegalVision's employment team. I'm joined today by my colleague Louise Miao, who is also an associate in our team. So before we begin, just a couple of quick housekeeping items. You will be emailed the recording and slides of this webinar, so don't feel like you need to be furiously writing notes. You can also submit questions you have in the chat box and we will try get to them, all of them at the end of the presentation. And we would also really appreciate it if you could complete the survey that pops up after the webinar. We really do value your feedback. So all attendees are also eligible to receive a free consultation with us to discuss how we can help you with any of your legal needs. To request your free consultation, just provide us with your contact details in the survey that appears at the end of this webinar. So today we'll be providing you with a bit of an overview of employee rights and employer obligations when it comes to absences due to illness or injury. Then we will outline some best practice approaches for managing short and long-term absences. And finally, we'll give you some practical tips for dealing with absenteeism in your workplace. So Louise will kick us off by giving us a summary of employee rights in relation to temporary absences from work due to illness or injury.
Thanks very much, Ruby, and welcome everyone. As I'm sure many of you are aware, employees have a number of rights and protections when it comes to being absent from work due to illness or injury. First and foremost, the Holidays Act provides that all employees are entitled to sick leave after 6 months of current and continuous employment, regardless of how many hours of work they work a week, or whether they are part-time or full-time employees. If they have not had 6 months of continuous service, then they will be entitled to sick leave if over the last 6 months they have worked for you for at least an average of 10 hours per week and no less than 1 hour in every week or 40 hours of every month. The Holidays Act provides all full-time and part-time employees with 10 days sick leave for each year of service with their employer, and this leave is cumulative from year to year but not payable upon termination. Your employee may be able to access sick leave if they are not fit for work because of a personal illness affecting them, or where they are required to provide care or support to a member of their immediate family or household. It is important to note that there is no statutory entitlement to unpaid sick leave once your employee has exhausted their sick leave balance. However, your employee may request to use their accrued annual leave if they have exhausted their sick leave balance, and any such request should not be unreasonably refused. Finally, your employee is also obviously entitled to a safe workplace in accordance with work health and safety legislation. Knowing then the rights and protections for your employees, it's worth now taking a look at your obligations as an employer when it comes to employees being absent from work due to illness or injury. And now I'll hand back over to Ruby.
Thank you for that, Louise. So it is important to note that obligations and entitlements differ for employees if they have had an accident or injury that is covered by ACC. So when your employee has an accident or injury, whether it's work-related or not, your obligations will be slightly different. In New Zealand, any person injured in an accident receives Accident Compensation Corporation, or otherwise known as ACC payments. So as an employer, it is important to note that you do not have to pay your employee if they are receiving ACC payments. You cannot make your employee take sick leave or annual leave if they are receiving ACC compensation. And you can agree to top up the employee's payments to 100% by using 1 day of the employee's sick leave for every 5 days leave taken. So if an employee is sick or has suffered an injury and is absent from work on sick leave, or as they are receiving ACC, employers have an obligation to be fair and reasonable when dealing with all employees. But what does this mean when dealing with long-term absences? In relation to sick leave, the employee has first to receive his or her paid sick leave entitlement under their employment agreement, which can't be less than the minimum entitlement set out in the Holidays Act. And if the employee has been sick for a prolonged period, the employer can usually require that the employee provides medical certificates for this absence at their own cost. As an employer, it is good practice to open up a good line of communication with the employee. The employee should be asked to keep the business regularly up to date and to provide enough details of their sickness or injury so that the employer can understand the situation and their likely return date. If the employee is on ACC, the employer will also need to liaise with the ACC case manager allocated on the matter. Louise is now going to get us started with how employers can look to manage shorter term absences, and following that I will address the same in relation to long term absences.
Thanks very much, Ruby. Now it's clear that in circumstances where an employee has been absent from work for less than 3 months, a short-term absence is never really going to result in a reason for dismissal due to the protections Ruby has just mentioned. So the question remains, how can you, as an employer, manage short-term absences? Well, as employment lawyers, we see a number of common mistakes that employers make when managing short-term absences. Some of the most common pitfalls that you should avoid include, in terms of process, not having clear policies setting out the correct process for your employees to notify you of their absence or the provision of evidence supporting such absences. In relation to enforcement, not enforcing the standards set out in your policies. And lastly, consultation, not managing the sick employee from the first absence and keeping in regular contact with the employee during their absence. To combat these pitfalls, there are a number of steps you can take as an employer. For starters, you can implement and maintain policies requiring your employees to notify you of their absence in accordance with your directions. For example, you could make it a requirement that all employees notify their immediate manager by telephone rather than text as soon as possible before the start of their rostered shift. Or you could require the provision of a medical certificate if the absence is either side of the weekend or for more than 3 days in duration. If your employee does not follow the evidence and notice requirements contained in your policies and procedures, this may also present an avenue for you to take disciplinary action against them for failure to follow the lawful and reasonable directions contained in such policies. For this reason, it's important to ensure that you document and address any non-compliance with your policies as it arises. You can also request medical certificates in support of any absence due to illness. If your employee fails to comply with your lawful and reasonable directions to provide medical certificates, you have the discretion to deny the employee paid sick leave. Regardless of whether your employee provides medical certificates to support their absence, once your employee exhausts their accrued sick leave, they will be on unpaid leave unless they have requested to use accrued annual leave. And in our experience, if an employee is no longer being paid, this may discourage them from taking further sick days. Finally, we also recommend regularly consulting with your employees to inquire as to their health, well-being, and fitness to work. For instance, if you have detected a pattern of excessive absenteeism, your first step should always be to talk to the employee and try to pinpoint the cause of the repeated absences so you can adopt an appropriate strategy for managing the absenteeism moving forward. This may assist with workforce planning and allow you to put measures in place to assist with your employee's eventual return to work, as well as ensuring that the workplace supports its workers' health and well-being more generally. By implementing these measures, you can reset expectations for your employees regarding absenteeism due to illness or injury and have a clear strategy in place for managing employee absenteeism moving forward. And now I'll pass back to Ruby to talk about long-term absences.
Thanks, Louise. So as an employer dealing with long-term absences, it will often be at the pointier end of the scale as far as risk is concerned, as it will often involve circumstances where an employee is receiving ACC for an ongoing period of time, or they have been on extended sick leave. However, eventually an employer may come to a point where it considers it cannot keep the employee's job open any longer. So before termination for medical capacity is considered, another option is to consider medical retirement. This allows an employee to leave an organisation with dignity, and it's a bit different from normal retirement because after normal retirement, the employee doesn't often work again. But after medical retirement, the employee often looks for a different job that is not limited by their illness or injury. A key point is that medical retirement must be agreed by the employer and the employee. So employers should consider discussing it as a possible option with the employee before deciding on dismissal for incapacity. Medical retirement provisions may be in an employment agreement or workplace policy, but even if they're not, the employer and the employee can still agree to medical retirement. However, we always recommend this should be in writing. An example of this is a case we had recently where our client's employee unfortunately suffered a heart attack during his first week of employment. So the employer and the employee in this situation, both with guidance from the medical professionals, agreed that the employee would not be able to continue in their role, and the employee agreed that it would be appropriate for them to medically retire. However, if after a fair process and discussion has been held, the employee does not agree to medical retirement and doesn't want to resign or otherwise leave their employment, and the employer decides there is no alternative but for the employment relationship to end, then the employer may need to use dismissal for medical incapacity. This point will vary from case to case, and it depends on a whole range of factors. It is important to recognise that there is no one-size-fits-all approach that can be taken here. So before dismissal for medical incapacity will be lawful, it is important that the employer carries out a full and fair investigation into the employee's true medical position. This includes considering their present state of health, making sure that the employer has considered the effect it's been having on their business, the importance of their role, the ability to find temporary coverage for their role, and the employee's prospects for recovery, whether the illness or injury occurred at work, and as well as the expected length of time away from the workplace. So it is important to note that an investigation into an employee's medical prognosis is not a disciplinary investigation. An employer must also notify an employee of the possibility of dismissal from the outset of the process, seek their feedback throughout, and carry out a full and fair investigation into their true medical position. So whilst on leave for workplace injury, the Employment Relations Act and the Human Rights Act provide protections for employees from being dismissed and discriminated against during their injury and absence from work. An employer is permitted to dismiss the employee only if through a process of medical examinations, evidence, and professional advice, it is determined that the employer will not be able to return to the job or an adapted version of the job within a reasonable time frame. So this involves taking all practical steps to assist an employee with their rehabilitation, regardless of whether or not the injury occurred at work. This means that an employer must genuinely consider and often offer workplace alternatives where possible, rather than dismissal. For example, an employer may be able to accommodate light duties or reduced hours. However, there is no obligation on an employer to accept an employee on light duties or reduced hours forever, if at all, or to create an entirely new role to accommodate an employee. So in some circumstances, it may be appropriate for an employer to communicate directly with an employee's medical professional and ACC case manager, provided they have consent to do so. It may also be appropriate for an employer to ask an employee to put forward specific questions to a medical professional or to request the employee meet with a different one. So both parties must be responsive and communicative with each other, and any request made by an employer must be reasonable and directly relate to the employee's return to work. An employer should also bear any costs associated with its requests. So once all of these issues have been considered and discussed with the employer may be in a position to issue a deadline that if the employee cannot return by that date, then an option may be that the employment will need to be terminated. Employers should be aware of the legal complexities involved with dismissing an employee based on medical incapacity and should seek legal advice before doing so. So ultimately, a medical incapacity process is about balancing fairness to an employee against the needs of an employer's business. Only after these considerations are made and a proper process is followed should an employer consider dismissal for medical incapacity. Employees should also be aware that it is common for a dismissal process to take a number of weeks, if not months, and there will be a number of meetings or exchanges of information, and dismissals of this nature are generally quite rare. If you have any questions about the above or are looking to embark on this process, please get in touch with our employment team who'll be happy to assist. So Louise is now going to give us some practical tips on how employers can approach and manage absences in the workplace.
Thanks, Ruby. Well, it's clear that there are a number of protections and risks involved with managing employee absences due to illness or injury. So it's important to consider what practical steps you can implement to manage absenteeism moving forward. First and foremost, we strongly recommend implementing and maintaining absenteeism policies dealing with notification procedures and requirements for the provision of medical certificates. These policies should be enforced consistently across your business with every employee with every absence. Secondly, you should consult with the employee often. You can use this as an opportunity to gain more information about your employee's illness or injury, including details about the current treatment and any relevant timeframe in relation to their recovery or return to work. As discussed earlier, we also recommend requesting the provision of medical certificates or other evidence supporting an employee's absence due to illness or injury. Where medical certificates do not provide sufficient information or where the absence is no longer temporary, it may also be appropriate for you to seek an independent medical assessment structured to address your employee's ability to perform the inherent requirements of their role. Finally, before taking steps to dismiss your employee, you should determine whether your employee can perform the inherent requirements of their role with or without reasonable adjustments, and also follow a procedurally fair process in relation to the dismissal. And so that concludes the main part of our webinar. You might find our publication, the How to Hire Inspire Guide, useful. You can download it via the handout section in the webinar panel, or you can use the QR code on the screen. We also have an upcoming webinar that may be of interest to you. This covers sexual harassment and bullying and your duties in the workplace on Tuesday, the 15th of August at 12 p.m. And you can also register at the link on the screen. We're going to answer your questions shortly. And while you submit them, we'll take a minute to tell you about our membership. LegalVision's membership is a cost-effective alternative to the expensive hourly rates that you experience at other law firms. For an affordable monthly fee, you receive cost certainty and an all-inclusive legal service, including unlimited document review, such as drafting, amending, and reviewing business contracts and commercial leases. It includes unlimited advice consultations with our teams, including business structuring, employment, disputes, and more. And it also includes unlimited domestic trademark registration. As a LegalVision member, you won't have to worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of the business as usual legal work, so you can focus on running your business. And if you are in-house counsel, our membership is a cost-effective solution for outsourcing additional legal work. To learn more about how membership can help you, request a free consultation when the survey appears at the end of the webinar. So now we're going to answer some of your questions. So the first question that we have here is, what if we think a medical certificate is fake?
So as an employer, if you have genuine suspicions as to whether the medical certificate is fake, you can contact the doctor to verify the medical certificate and make sure it's genuinely issued, but you cannot ask for the medical history of the employee or their reason for the doctor's visit.
Thank you. The next question we have is, can an employer ask for a medical certificate even if it's for 1 day of sick leave?
So generally, the law on this is that you need to wait 3 consecutive days before asking your employee to provide you with a medical certificate, or you can request it earlier if you pay for their doctor's appointment. So again, you can't force an employee to have a medical examination or tell them they have to visit a doctor, but if they refuse to provide a medical certificate, then you don't have to pay for their sick leave. So generally we recommend waiting 3 days, or if it's for a very good reason, perhaps requesting that they go see a doctor and you have to pay for it.
Thank you. The next question we have is, can employees use sick leave for doctor's appointments in New Zealand?
So typically an employee cannot use sick leave to attend a doctor's appointment unless their employer agrees to it. So the reason for this is because going to the doctor is not considered the same as being sick or injured.
How should an employer manage a situation where an employee takes excessive sick leave for genuine sickness and has exhausted their entitlements, needing to take LWOP continuously?
So I think that comes into considering on what I discussed about managing longer term absences. So the two options here, like we discussed, was sort of the possibility of medical retirement or dismissal for medical incapacity. As discussed, it's quite a complex process. So we recommend if there is an employee who's having extensive time off, that an investigation and a fair process is carried out. But ultimately, we'd recommend seeking legal advice before doing so. As discussed, it's quite a difficult process, but those are probably the two avenues to look down for that type of employee.
My business is a small business. As such, there is little ability to put any employee on light duties. What can I do?
So as touched on, there is no requirement to give an employee light duties if there is no option to do so. So I guess again, it's being fair and reasonable, making sure you've considered all possible options to assist the employee. But ultimately, if there is no possibility to give light duties or reduced hours, then the answer doesn't have to be yes.
What is the best approach when a staff member is having a lot of time off due to stress and burnout, but they also have a number of performance issues that they need to be addressed? From a health and safety perspective, it appears that the process leans on the side of the employee rather than the employer.
Yeah, so it's quite important to remember that any time off for stress and burnout is probably very separate to performance issues, and we generally recommend not confusing the two. So I would recommend if you're going to approach either one, they're quite separate. So one would be dealing with the stress and burnout, that would be to do with the leave. Obviously, that's again the illness and sickness and things like that. And then performance is entirely different. That's more of a disciplinary process. So I guess our advice would be to seek legal advice on which avenue you want to pursue, if any for either of them. But yeah, they are quite separate. So I think that's the key to remember, is to not confuse performance issues with any sick leave.
We have another question here. So if you write a policy that requests the employee provide a medical certificate, does the employer have to pay for the doctor's visit?
No, not if it's after the 3 consecutive days. So generally our policies, we recommend including that one is required after 3 days consecutive sick leave. Again, touching on that point, if it's any earlier, you will need to pay for it because that's sort of the direction.
That's all the time we have for today for questions. After the webinar ends, a survey will pop up. We would really appreciate it if you could complete the 30-second survey, and please include your contact details to receive a complimentary legal consultation to discuss how we can help you with managing employee sickness and absence.
Thank you.